Without wasting any time, Chair, I'll just allow my colleagues to go through the presentation so that you can give a briefing on the progress of the investigation. Thank you.
Thank you, Mr. Lekgetho. Morning, everybody. All protocols observed. As requested, the SIU has prepared an update specifically focusing on the Mopani and Giyani and to give feedback on the site visits that the SIU also attended with SCOPA. We've included here the section of the proclamation that is relevant. I'm not going to read through it. It is merely there for reference. Just by way of background, we've set out all the events that led up to the contracts that were awarded to LTE, in particular in August of 2014, where there was an imbizo held by the former Minister of Water and Sanitation to address the challenges in Giyani. During our use of our powers by way of a Section 5 to B and C hearing that was held at the SIU, Mr. Majola from LTE confirmed he was present at that imbizo in Giyani in August and mentioned that the CEO of Lepelle Northern Water had proposed ideas that can resolve their challenges there through his company LTE. On the following day, LTE representatives were present at the task team meeting called by the Minister, even though the task team was supposed to only be attended by officials from Mopani District Municipality, the Department, and LNW. LTE was present at the task team meetings before LNW started with the SEM process to appoint a service provider for the project. Further background, LTE was initially appointed on an emergency basis in August 2014 for the repair and refurbishment of the water and wastewater works to the value of 90 million rand. The appointment dated 20 August 2014 was informed by a directive issued by the Minister on the 25th of August requesting LNW to intervene on an emergency basis with regards to the water challenges in Giyani. The Minister indicated that the water treatment work should be completed by no later than 30 September 2014. 25th of September 2014, LNW then appointed LTE, the service provider for non-emergency works, to the value of 2.2 billion rand. It must be noted there was no procurement processes followed when the project was extended from the 90 million to the 2.2 billion. It must further be noted that the directive issued by the Minister in August of 2014 was not extended to include non-emergency projects. LNW thus extended the project to include non-emergency works, increasing it from 90 to 2.2 billion without authorization from the department, as there was no extension to the directive from the Minister. SIU is of the view that if a new directive was issued to include non-emergency works, then they would have still been required to go out on a competitive bid. The appointment of LTE can effectively be divided into those two stages. The first appointment for the emergency work for 90 million rand, and then the second stage for the refurbishment and repair of Mopani water and wastewater to the value of 2.2 billion rand on a turnkey basis. The allegations came to the SIU by way of a whistleblower report, and these allegations were to the effect that there was reason to believe that the award made to LTE was without any competitive bidding or SEM process having been followed, and that LTE is a professional services engineering firm which rendered consultancy services to its clients and did not have the capacity or experience to execute or manage a turnkey project. There were 6 focus areas of the investigation looking at the SCM as well as the extension of scopes, whether there was a CIDB compliance, allegations of corruption, and investigation into the payments that were made to LTE and other contractors as well as value for money. The findings into our SCM investigation, as stated, there was in August 2014 the letter of appointment to the deviation from the normal procurement process for 90 million. In September, it was extended to 2.2 billion, and in October 2014, a revised appointment letter to LTE and a service level agreement for Mopani water and wastewater emergency intervention, which includes Giyani water and wastewater schemes on a turnkey basis. Our investigation revealed that the second appointment was concluded without following any SCM processes. The project cost was increased from the approved budget of 90 million to 2.2 billion. We found it was contrary to the directives of the Minister, and it was without an approved budget plan. In light of the above, the appointment of LTE by LNW at a contract value of 2.2 billion was irregular, unlawful, and it was concluded without due regard to Section 217 of the Constitution, LNW's SEM policy, and the directives of the Minister. In terms of the findings into the CIDB compliance, it was found that the appointment of LTE by LNW in August and September were irregular and unlawful in that LTE was not registered with the CIDB to undertake or carry out construction work for public sector contracts, and LNW was prohibited in terms of the CIDB Act to appoint a contractor to carry out construction works without a valid registration certificate issued by the CIDB. Findings into the payments made by LNW. The investigation uncovered that LNW had paid an amount of approximately 4.1 billion to the service provider, which far exceeds the original contract value of 2.2 billion. Findings into the corruption investigation. The SIU identified a corrupt relationship between the LNW officials, service provider, and department officials. Findings into the value for money assessment. We originally looked at 5 sample boreholes. The SIU contracted the services of an expert to conduct value for money for those 5 boreholes of the 167 that were installed by the service provider. The report obtained from the expert quantity surveyor identified that there was excessive overpricing on the boreholes, amounting to approximately 7 million rand. Bear in mind, this is just the 5 boreholes that were sampled. And there were non-functional water purification plants, which had been 2.5 million had been paid for. The expert thus quantified that LNW did not receive value for those 5 boreholes and overpaid a total of 9.5 million rand, either due to the non-performance or the inflated project costs. The findings submitted by the QS are tabled in the next slide, which sets out the location of the boreholes. The column on the right in the red indicates the difference between what was charged and what the correct estimated charge should have been by the QS. So, for example, on line 1 there, the actual cost there is 1.250 million. The estimated amount by the quantity surveyor was 1.1 million, and the variance there is 57,000. And so it goes down to bring it to a total of 7,048,712.35 at the bottom. That is regarded as being overpriced. Findings into the value for money assessment. Here, there was a broader assessment of value for money that had been provided in terms of the infrastructure at Mopani and Giyani. In respect of the infrastructure listed in the bullets below, the SIU also contracted the services of an expert to conduct this value for money exercise on work that was done by the service provider. They looked at the refurbishment of the existing water and water treatment works, the upgrading of electromechanical equipment at water pump stations, installation of pipelines, and the balance of the 167 boreholes. The expert found that the costs had been inflated by the service provider by approximately 893 million rand, excluding VAT, on the above work that had been reviewed. And the SIU has those 2 expert reports, which we will be using down the line in the litigation. Outcomes, this is where we get to the consequence management, which was one of the undertakings the SIU made to provide comprehensive feedback on when we did the site visits. There are 4 civil litigation cases that I'm going to outline here. The first one is the SIU's main application against LTE and Co. The investigation into the SCM was completed and we found the contracts were irregularly awarded, and as a result, we issued summons on the 26th of November 2018 in the High Court, Limpopo Division, Polokwane. The civil action is to have the contract to the value of 2.2 billion declared unconstitutional, invalid, and to have it set aside. The quantum of the contract and what was paid out has subsequently increased to 4.1 billion, and we've increased our litigation to recover that amount. The parties to the litigation are set out below there. Safe to say they include LNW, LTE Consulting, Cato Civil, South Zambezi Engineering, Mopani District Municipality, and the Department of Water and Sanitation. Continuing in respect of this first case, in May, Senior Counsel advised the SIU to file for an objection, which was served in 26th of May 2013. We then dispatched a letter to Senior Counsel, to the Deputy Judge President of the High Court in order to enroll the matter on the interlocutory motion roll. And in October 2023, the SIU applied for a hearing date and filed a directive compliance affidavit. Safe to say we wait to hear from the Acting Judge President of the Polokwane High Court in order to allocate a hearing date for this case. This matter was brought to court prior to the SIU's special tribunal being relaunched, hence it is in the ordinary High Court in Polokwane. The second civil litigation case was one that was brought against the SIU. Mr. Lachodi and the former Lepelle Northern Water Board applied for an interdict against the SIU to prevent the unit from conducting further investigations. The interdict proceedings against the SIU requested the court to order the following terms: that the investigation by the SIU of the private and personal affairs of Mr. Lachodi is not authorized by the proclamation, and that the investigation by the SIU of the private and personal affairs of Lachodi is unlawful and unconstitutional, and they asked for the SIU to desist and refrain from carrying on with the said investigation. The former Lepelle Northern Water Board withdrew as a party to the proceedings, and Mr. Lachodi later abandoned the process as well, but we still had to defend this matter in court. It is now considered closed. The third civil litigation matter, this is where the SIU brought a damages claim against the former LNW officials. On the 6th of October 2020, the SIU instituted civil proceedings by way of a damages claim in the special tribunal. Case number there refers against 3 former employees of Lepelle Northern Water, Mr. Carl Schmal, Mr. Phineas Lachodi, and Mr. J. Killian, to the value of 1.9 billion rand in damages that they caused to LNW. This is in relation to the unlawful conduct, breach of financial duty or duty of care towards LNW by the above-mentioned employees in the process that led to the appointment of LTE Consulting by LNW. The matter has been enrolled for hearing on the 20th of November 2023 in the Special Tribunal, and we will keep the committee abreast of developments there. The fourth civil litigation case, and this is in respect of the SIU's action to freeze assets and pensions of those same implicated officials we just spoke of. The SIU successfully submitted court applications to the Special Tribunal to preserve the pensions of 2 of the implicated LNW officials. Mr. Lachodi's pension to the value of 2.4 million rand and 4 immovable properties just under 10 million rand have been frozen. And Mr. Schmal's pension, valued at 10 million rand, has also been frozen. Mr. Killian, we were unable to take action against, as he is out of the borders of South Africa and had resigned or retired quite some time ago as the former CFO at LNW, and had withdrawn his pension before we could freeze it. The above pensions and properties will remain frozen pending the outcome of the damages claim against the former officials in the Special Tribunal. The previous slide refers. Further on the consequence management, as Mr. Lekgetho mentioned, we don't wait for the presidential report. As soon as evidence supports any action, remedial action, consequence management, that is referred and immediately acted upon. We made a disciplinary referral in respect of the LNW CEO in February of 2018 for negligence and contravening the PFMA. Mr. Lachodi resigned before the disciplinary was held. We also made a referral in respect of the manager planning, GIS at LNW, that is Mr. Schmal, in September of 2018 for collusion, fraud and forgery. His hearing was held in November 2020, quite some time later, and he was dismissed in December of 22. Further criminal outcomes were that we made referrals to the NPA in terms of the former CEO for contravening the PFMA, as well as against the manager planning for collusion, fraud and forgery. The SIU has been working closely and in collaboration with the Specialized Commercial Crime Unit to accelerate the prosecution of all matters that has been referred to the NPA in respect of these investigations. We are informed the criminal prosecution has been prioritized into 2 stages and significant progress has been made. We also referred evidence to the Construction and Industry Development Board, pointing towards contraventions of their act in December 2017, and we were advised that they are following up on our recommendation. The investigation has been concluded and the final presidential report is being finalized for submission to the presidency. We now get to the oversight visits, where the SIU attended with the Standing Committee in March of 23. We visited the following sites and projects there: the Nandoni Dam, Pikawani Canal and Giyani Wastewater Treatment Works in Tomo Village. The following villages form part of the works where one service provider was appointed, and they are listed there. On conclusion of the 3-day oversight visit, the SIU undertook to provide feedback on the following deliverables: the finalization of the presidential report in respect of Guyani, status of consequence management arising from the findings of the SIU, and a new motivation for a proclamation in respect of allegations at the Mopani reticulation projects which were brought to our attention during the site visit. Feedback on our undertakings: the presidential report, it's at its final stages of being reviewed and then will be submitted to the President. As explained, it is not in any way delaying any consequence management taking place, as has already been reported and is summarized here below. The status on consequence management, we've given a detailed update there. As said, these actions are not reliant on conclusion of the presidential report, which is to serve the President with what has already been done in respect of consequence management and the status thereon. To summarize the SIU's outcomes on consequence management that has taken place already: 2 civil cases launched in the High Court for 4.1 billion and the Special Tribunal 1.9 billion. 2 orders from the Special Tribunal freezing 2 pensions and 4 properties. 2 implicated officials no longer in the employ of LNW, 1 resigned, 1 dismissed. Criminal and CIDB referrals done, and the SIU working with the SCCU task team to accelerate those prosecutions. The third undertaking was that the SIU would look into a request to motivate for a proclamation into allegations at the Mopani reticulation projects. It was discovered during the oversight visit that 37 water reticulation projects in Mopani were allocated to 1 service provider, and about 2 years later the villagers still do not have water. We are collecting the relevant information to support those allegations that were brought to our attention in order for us to determine whether we should draft for a motivation for a proclamation, as those allegations do not fall within the scope of our current proclamation. These are some of the observations that the team made during the oversight visits to Guyani. This is the Guyani water treatment plant, and we've just made some comments here in terms of what we already found in our investigation. LNW paid 77 million for the revitalization of the Guyani wastewater treatment plant. It was constructed in October 2014 and worked for only 4 months. Mopani District Municipality then had to resort to the use of the old treatment plants that existed before this one. 77 million was paid to cater, and it has not benefited the community. The team also observed a vandalized building, the Guyani Wastewater Treatment Works. This was officially opened by the former president in 2014, and 77 million rand was paid for the revitalization of these water treatment works. The building attached to the treatment works has since been vandalized and is not fully functional. The Guyani Wastewater Treatment Works revitalization of package plant. The revitalization of the package plant formed part of works investigated in Proclamation R22 of 2016, and the investigation established that Cater Civils was contracted to build the Guyani Wastewater Treatment Works revitalization at a total cost of 75 million. LNW paid Cater an advance of 15 million 2 months after signing the contract. Even though the contract price was 75 million, LNW paid Cater a total of 247 million. The treatment works were functional for only 4 months after completion in 2015, and after that the municipality reverted to the old wastewater treatment. These are water leaks that were observed by the team who attended the site visits at the Guyani water treatment works. These were identified at that water treatment plant and the Nandoni treatment plant, and no proper management of plants and water is lost due to the various leakages. The SIU also observed pipes that had been abandoned near the Nandoni Dam. Hundreds of bulk water pipes were found abandoned in and around Nandoni Dam. It was identified that the pipes were left by the service provider who was appointed by Mopani District Municipality prior to 2014 and whose contract was subsequently declared unconstitutional by the court and terminated in 2014. This was not a matter that SIU was involved in. The new service provider was appointed and bought new bulk water pipelines. The SIU established that the Hawks are at an advanced stage of their investigation into this Nandoni and Sami Dam bulk water pipeline project, and the SIU is providing support to the Hawks task team led by Specialized Commercial Crime Unit of the NPA. I've then also just included a quick update on the Vuwani pipeline, which is quite an old matter and was investigated under the 2012 proclamation. I'm only going to touch on the updated matters that are relevant, and there are two live matters in respect of this one here, and that is the disciplinary against the former DDG at the water trading entity, Ms. Mate, where she was found not guilty in respect of the evidence referred against her here. The SIU has assisted the DWS, and there is a review application that has been filed at the Labour Court. I understand that there is another pending process involving the same official that is also being taken on an appeal, and these two matters are being monitored by the SIU for progress. The other live matter here is the civil litigation, where the SIU has brought a damages claim to the value of 95 million rand. And that damages claim is brought against Ascal Construction, who was a service provider, and their director, Mr. Sikosana, Ms. Mate, and Mr. Mpho Mofokeng, the former CFO of DWS. There's an update on the civil litigation listed there. Safe to say that the current status is that in April of 2023, a costs order was made by the court against Ms. Mate, as she had defaulted on providing feedback on the civil litigation progress. The SIU filed an objection against the amendment that was filed by Ms. Mate, and that objection notice was served in May of 23. We have written to the Deputy Judge President and waiting for a trial hearing date, and have filed the necessary compliance affidavit as part of that application. So those are the two live matters that we are monitoring in respect of this Vuwani pipeline, which is long concluded and reported on to the President. The status of the project currently there is that during the litigation, it came to the SIU's attention that the department had embarked on steps that could be considered as amounting to repudiation of their obligations in terms of this contract. And this was done by the department to address the lack of service delivery on the ground and the failure of the Vuwani pipeline being operational and delivering water to the community. This specific service provider had the middle 10 kilometers of the 30-kilometer pipeline, and without that functioning, the other two service providers who did the 10 kilometers either side of that middle section, the pipeline was not functional. The SIU assisted the department with providing legal advice as to the correct way in which the contract should be terminated, and the department accepted advice and undertook to implement such. And that is the update from the SIU side. Thank you very much for the opportunity.